Good morning, everyone. Welcome to the Ufberg and Associates COVID-19 update for employers. I'm Victoria Rogers with the Greater Scranton Chamber of Commerce. We have John Ellis with us today and Mary Walsh Dempsey from Ufberg and Associates. They have a great presentation for us today. I just wanted to go over some housekeeping notes before we start. We are recording this seminar today, so we can post it on our web pages and social media outlets later. So if you miss anything, you'll be able to see this again. I also have the presentation if John and Mary are okay with sharing it with everyone after this. Also, feel free to ask questions during the seminar. Mary will be watching the chat box down below. It's in the middle of the screen. Feel free to ask questions. And if you have anything you want to add or ask, please feel free to. And
join the meeting.
With Mary, go ahead.
Thank you, Victoria. Thank you.
Join the meeting.
Good morning, everyone, and thank you for joining us today. We appreciate it. Some of you may have participated with John and I about, I think it was March or April of last year when all of this was quite uncertain when we were at the beginning of COVID-19. A lot of it has settled down, but a lot of it still has some uncertainty. So we're glad you joined us today. There are important questions that still need to be answered on behalf of employers. Our title today is COVID-19 Update. So we'll do our best to kind of summarize or give a synopsis of what has occurred in the law and other Department of Health directives, et cetera, relative to COVID-19 and the management of your workforce. So for the purposes of today's presentation, we're going to use John and I a frequently asked questions approach that we will pose popular questions that he and I, more he than I, to be quite frank, because this is his expertise, have received about COVID-19, and then we'll give you the specific answer. So we're hoping these questions, because we've heard them so much over 10 months, will then again be applicable to you in your workforce. We have decided, since it is a little bit more of a smaller and intimate group, that we would like to take questions as we go on. So as Victoria said, I will monitor that box and I will be glad to pose that question to either John or I at the proper time. I want to thank everyone for being here, and I'm going to turn it over to John, who's going to get started with us on COVID-19 vaccinations, a very, very hot topic right now.
Okay. So, our first question and answer here is, can I mandate that my employees get a COVID-19 vaccination? And I think if we were going to identify the most popular question that our office has received in the last 3 months, this would be that question. So I'm going to give you the practical answer first and then go into a little bit more detail. Legally, for most positions, you can mandate a COVID vaccination, but only with big exceptions for religious beliefs and medical issues. Now, we'll talk about more information about what that means in a few minutes. In a nutshell, our recommendation is that employers make vaccinations voluntary rather than mandatory, even though you could mandate. And I think you'll understand why we're saying that as we go into more detail on the next few slides. So first, we'll talk about ADA, Americans with Disabilities Act limitations. And employers can only require employees to undergo a medical examination under the ADA if that medical examination is job-related and consistent with business necessity. So, an obvious question here is a vaccine a medical examination? And the actual shot in the arm itself is not. But before a vaccine is administered, a healthcare provider is required to ask several questions about pre-existing health conditions and potential vulnerabilities. And those questions are a medical examination. So as a result, the question is going to be, is this vaccination job related and consistent with business necessity for every position in your business? And, for some positions, I think that answer is going to be obvious. If you have an employee who's in a manufacturing environment, who's working very closely or in close quarters with other employees and they can't separate, I think you have a good case that that'll be job related. Healthcare providers, particularly healthcare providers that are caring for COVID patients, I think, again, you have a good argument that that's job related. Education, I think there's a good argument there. But certain other positions that can work remotely, for example, or rarely have contact with the workplace, you may have a legitimate question there as to whether that is consistent with business necessity. So that's something you have to think about. There may not be a one-size-fits-all answer to this in a lot of businesses. Even if you conclude that the vaccination, that the medical exam, the questions that come with the vaccination are job-related and consistent with business necessity, your mandate still has to include two large exceptions. The first is an exception for sincerely held religious beliefs. And there are some employees who have religious creeds that would militate against vaccination. Now, reasonable accommodations for a sincerely held religious belief are, legally speaking, relatively easy. You need to grant an accommodation as long as it doesn't impose more than a de minimis cost. The second exception, reasonable accommodation for employees for whom a vaccine is not medically advisable. In other words, where a doctor says, you know what, you have a pre-existing health condition, I don't think you should get this. That's much harder. There you have to follow the typical reasonable accommodation rules under the Americans with Disabilities Act and engage in the interactive process with employees as you would really for any disabling condition. And as I think most of us know, it's relatively easy for an employee to get a doctor's note setting forth work limitations. So I think that, if you have an employee, my expectation is if you have an employee who does not want to get a vaccination, they're likely not going to have too much difficulty finding a doctor's note to say it's not medically advisable. So, in a larger sense, we're talking about reasonable accommodations here. What is a reasonable accommodation in the COVID vaccination context? And in a very real sense, we don't know yet. And the reason we don't know is that right now, the same mitigation requirements, the same masking and social distancing requirements apply to vaccinated and unvaccinated individuals alike. And the reason for that is, in terms of clinical evidence, right now, the FDA has not published any studies or reached a portion of its approval process where there's clinical evidence to support that the COVID vaccinations that are currently available prevent transmission. Now, I should say healthcare providers believe they prevent transmission, and I believe there have been medical journal studies that indicate that the Pfizer and Moderna vaccines prevent transmission. But right now, there's been no clinical evidence of that from the the FDA. Too many acronyms. And until we get that, I don't expect that we're going to see any difference in mitigation requirements for vaccinated or unvaccinated individuals. It's also worth noting that most existing case law on vaccination issues involves flu vaccinations. And in the flu vaccine context, healthcare providers, which have generated, as you would expect, most of the case law on this, have generally concluded that a reasonable accommodation for an employee who doesn't get a flu vaccination is that the employee has to wear a mask during flu season. Now, you can probably see where I'm going with this, because right now everybody's wearing a mask to help prevent COVID transmission. That's a standing order from the Pennsylvania Department of Health, and it's a recommendation from the CDC and OSHA. So really, if that's been good enough right now, I expect, although I cannot say for sure, that the reasonable accommodation for someone who doesn't get a COVID vaccine is probably going to be to simply continue masking and social distancing requirements indefinitely. If that does turn out to be the case, it's going to be difficult to argue that really accommodating an individual who doesn't get a COVID vaccination would entail more than a de minimis cost. So now we're going to get into a couple of practical concerns, and this is really where we're going to be addressing why we're recommending that we make it voluntary as opposed to mandatory. The first concern is the emergency use authorization. I think all of us know that the Pfizer and Moderna vaccines that we have out right now have not gone through a full FDA approval process. They're being issued under an emergency use authorization, which allows their administration earlier in the process than would normally be the case. Neither of the Pfizer Moderna vaccines or Johnson & Johnson, if it's approved this month as we expect, have completed the full FDA testing process. The Pfizer and Moderna vaccines also used a new method to come up with the vaccination, using mRNA to create the vaccine. Now, this is a scientifically proven method, but it was never used to create a vaccine before. And the reason for that is primarily logistical. As I think we've all seen in the news, Pfizer and Moderna have to be transported at an ultra cold temperature. And until COVID, we didn't have the investment in the infrastructure to transport and store those vaccines appropriately, which is why they haven't been used before. Now, I fully expect that now that that infrastructure is in place, we're going to be seeing a lot more vaccines that are made using this method. But right now, it's new. And when something is new, it tends to generate a lot of distrust in the public. And for that reason, people are fearful of the vaccine. And that brings us to our second practical concern, which is employee and labor relations. Now, survey data indicates that 20 to 25% of the population, even before COVID, would generally refuse vaccination or feared vaccination for various reasons. Survey data indicates that fear or distrust of the COVID-19 vaccination in particular is a lot higher. It may be as high as 45 to 50% of the population in many surveys. And there's a portion of that is indicated in surveys that they would resign their job rather than get a mandatory COVID vaccination. So the question we pose here is, if 25 to 50% of your employee population is fearful or resistant to vaccination, what will happen if you mandate the vaccine? Can you afford to have employees leave rather than obtain the vaccination? And we have a note here that across all industries, hiring is very difficult right now. Expressions about staffing concerns are a consistent comment that we have gotten from organizations we represent across all industries and locations. So all of these things, when you put them together, I'm not certain that, given the exceptions that you have to make, that a mandatory COVID vaccination is going to capture significantly more individuals than a voluntary program coupled with employee education. And employee education is key. You want to share resources with your employees to help them make informed decisions. We have some clients that have arranged for healthcare providers to give virtual presentations about vaccination and answer questions. In that regard, I'd like to give a plug to the Wright Center and the Abington Community Library. The Abington Community Library had Dr. Sheth, the Chief Medical Officer from the Wright Center, give a presentation on COVID vaccination a few weeks ago using video, which was a great presentation, and they received permission from the Wright Center to make that publicly available. So if you go to the Abington Community Library website, you should be able to find a link to that presentation. In my opinion, it's a very useful educational resource if you're looking for something to share with your employees. I can tell you that to date, our firm clients have not mandated vaccination, and to the best of our knowledge, that is the trend nationally. I would say there have been some high-profile stories of companies that have begun to mandate, or I know there's one a few weeks ago involving the city of Harrisburg. But I'd submit to you that the reason those stories are achieving such high profile is because they're so rare. And I think for virtually everybody, voluntary efforts coupled with education is the best way to go. So if we don't have any questions on that, I'm going to turn it over to Mary to talk about our next section here. Do I pay for a COVID-19 vaccination?
Thank you, John. I did check. I do not see any questions in the chat. Once again, for anybody who entered late, we're just asking that any questions be put in the chat, and that John and I will try and answer them interactively as we move forward. And one final comment on what you said, John. Well, I agree with everything you said. I think if it comes down to it, if it ever came to any sort of a people looking for preliminary injunctions or declaratory judgments to get people in their businesses to get vaccines, it's probably going to come down to what your business is. You know, I mean, if it's a hospital or a medical practice, I think there's your arguments are much different than John and I sitting in our law office 100 feet apart. So that's just something to keep in mind as well. So the next thing we're going to talk about, and it's going to be somewhat brief, but is there a cost to the vaccine itself? My daughter is a manager, and I know she is receiving this because some of the people that work for her, it's not on high hourly wage position. So for the majority of the people, the answer to this is no, which is good. Now, do not confuse this with COVID testing, okay? Because I've had multiple ones of those in my house, and sometimes you'll get a bill for that. This is the vaccine itself. What we are finding is that most private health insurers will cover the visit, whose primary purpose is to obtain the COVID-19 vaccination without copays. That's been our history thus far. If you get a copay, I don't think it's unreasonable to call them and say, didn't think there was a copay. I would not be surprised if that was taken off your record. I can't guarantee that by any stretch of the imagination. But again, this is what we're seeing historically with our large group of clients. You can also check with your health insurance provider to confirm that all costs related to a COVID-19 vaccination will be covered. So if you're planning on doing an employee rollout and, we're having someone coming for 2 days, for 4 hours each day, they're going to sit in a private area, which we're going to talk about later. When you're sending out your memo to your employee, let's be honest, that's something that's important to them. If they think they're going to have to pay $30, $40, $50, that could definitively change their idea about whether they're going to voluntarily agree or acquiesce to this, okay? So that is not a bad idea either. Just call and say, hey, here's our plan, and can you confirm for us that this will be covered? I think that gives your employees some sense of certainty. And if it's not, then you really get into an employee morale issue is, do you consider covering it for them in the interest of trying to get as many people as you can vaccinated? Okay, John, you can go to the next screen for me, please. This is another question we're getting an awful lot. Do I have to pay employees for the time spent that they're getting the vaccine? So again, a lot of this is keeping up your employee morale. And if you have a nice group of people, trying to do the right thing at the right time during a pandemic. But the answer to this is likely yes, okay? Especially if you're going to mandate the vaccination. So if you've sent out the memo, you've done the research, you've gotten the pharmacist or the doctor who's going to come to the office and give the vaccinations, you've created that they don't have to pay for it. If they're going to go to that private room for 5 or 10 minutes, they're going to get their shot. The last thing I would do as an employer is say, oh, we're going to dock you for that. I just don't think it's good employee relations, okay? So, and there are other parts too, relative to whether that is part of their work. And arguably, I do believe it is at this point. So payments should be made. The second part is, what if we make it voluntary, Mary? In other words, it's not mandatory. We're going to arrange for the provider to come to work, but we're going to say, hey, it's up to you. We are still recommending yes for the same reasons I gave you before, okay? Number one, you may have a last minute change of mind. Someone, I may come out and I may say, oh God, that wasn't bad at all. 5 more people may go in. But again, under the law, the issue becomes, are they still on work time? Most likely they're still at your place of business. Most likely they're just running away from one task they're doing for 5 minutes to go and get the shot and then come back. So your best efforts here, or the best advice thus far, is to try and pay for the short period of time that your employer is getting it. Now, what if the employer, I see a question real quick. What if the employer makes the vaccination voluntary, as John has spoken about extensively, and the employers get vaccinated on their own time? So Mary Dempsey works for Ufberg. He doesn't care if I get it. I'm going to my own doctor up in Tunkhannock. She's going to give it to me. I think there's an argument that you don't need to be paid for that. I'm literally on my own time. I'm not in the course and scope of my employment. I am not getting it because my employer has mandated it or asking me to. I'm really getting it because Mary Dempsey wants to go and get the shot. Okay. I'm going to take a quick look at Prashanta's question. I have read that some employers are offering incentives to those employees who take the vaccine. For example, gift cards. What are your thoughts on this? I'm going to give my 2 cents and then turn it over to John. What I have seen on this is it can be nothing more than a de minimis incentivization. So like a gift card, something small, but John, you can take over from there as what you're seeing with what our clients are actually doing in that regard.
Well, to my knowledge, we don't have any clients who have enacted an incentive program as such. I mean, I'd give you 2 general thoughts. I mean, first, as we say, we have, the reason we're saying likely yes and likely no on this slide is that all of these issues are very fact intensive, and you could come up with certainly a unique situation or structure what you're doing in such a way that the answer may change. What I have seen, and I'm not sure that I would call this as an incentive so much as removing a road bump to a potential vaccination. There are some employers nationally who have reached the conclusion that they're going to pay employees for time spent getting the vaccine, just as hours worked, whether they're required to do so or not, even if it's a voluntary program and the employees are getting it on their own time. And I think the logic behind that is sometimes an employee, these vaccinations are highly sought after and it can be difficult to get an appointment. And the employers in these cases, for instance, don't want an employee who has to be at a vaccine site at 10:30 on a Wednesday morning in order to get a shot to decide not to get a vaccine because they don't want to lose work hours. So I think that's the most popular one that I've seen. Employers who are opting to treat it as hours worked to avoid a potential incentive for employees to decide, I can't get it, not because I don't want it, but I can't get it for economic reasons. Beyond that, I mean, really an incentive could be, as Mary said, a gift card, it could be anything you would want to offer. My own 2 cents on this, I don't think incentives are going to make a big difference. I mean, if you have an employee who's concerned about losing work hours, I think it would make sense to work with that employee. If somebody's afraid of a vaccine or resistant to getting a vaccine or doesn't believe in vaccines generally, I don't think an incentive is going to make a big deal of difference in changing their mind. But your workforce is better than we do. So if you believe it will, then certainly that's something you can look at.
And John, before I turn this quickly back over to you to talk about quarantine, the only other thing I've seen in reading our business journals and our business guidance is maybe giving an hour of time. I've seen people do that. Okay, you're getting the shot today, you're getting an extra hour of time that can be used within a 1 week or 2 week period. Now, again, that has to be worked out with your payroll system, but that is, I think, considered de minimis. And I do know people are using that somewhat successfully as well. If there's any other questions on that, I just read an article on it and I will try and find it because I think it was an hour time, but I think it can also go up to 2 hours time. I just remember this de minimis provision. In other words, you can't write a check for $500 and say, Mary Dempsey, go get your vaccine. They don't want it to turn into that type of a situation. So if there's other questions on that, if anybody wants to find John or I after the presentation, we'll be happy to look up further guidance on it. And then John, I'm going to turn it back over to you for some quarantine advice, please.
Okay. So this has been another popular question. How long do I quarantine an employee who's been potentially exposed to COVID-19? And I'm going to move through this relatively quickly because, quarantines we've been dealing with quarantines now for over a year, but there have been some relatively recent changes to the quarantine guidance that have provoked a lot of questions from clients. And that change is really as follows. PA has adopted new CDC recommendations that reduce the length of a quarantine from the 14 days that were originally recommended. Now, an asymptomatic individual who's exposed to COVID-19 can end quarantine after a 10-day quarantine without a test. Asymptomatic individuals who were exposed to COVID-19 can end after 7 days if they receive a negative test on a sample taken on or after day 5 of quarantine. And I have an example of this on the next slide that I'm going to walk through because it's this 7-day quarantine issue that has led to the most confusion. In either of these cases, please note, be it 10 days or 7 days, an individual should continue to monitor symptoms for the 14-day period that was originally recommended. And if symptoms develop, the individual should self-isolate and contact their physician. So the example of the 7-day quarantine. Let's say that a hypothetical employee is exposed to the virus at a party on Saturday. Saturday is day 0. The employee can get a sample taken for a test on or after the following Thursday, which is day 5. If the employee gets a sample taken before day 5, it's no good. The sample cannot be taken before day 5. Negative test results come back the following day, day 6. The employee has to continue quarantining through Saturday, which is day 7. You have to complete the 7-day quarantine. And if asymptomatic, the employee can return to work as of day 8, which in this case would be a Sunday. The CDC has also updated its definition of close contact, which the state has adopted. A close contact now is an individual who is within 6 feet of an infected person for a cumulative total of 15 minutes or more over a 24-hour period. And that would be during the 48-hour period immediately preceding the onset of symptoms through the date that the individual to whom they were exposed entered isolation. So in other words, if an individual was exposed on Sunday, worked Monday, Tuesday, Wednesday, Wednesday they develop symptoms, and they isolate on Wednesday, the exposure period would start 48 hours earlier. So it would be beginning of the day on Monday, Tuesday, and Wednesday through the time they left work and started isolation. Any exposure for 15 minutes, total exposure of 15 minutes during any cumulative 24-hour period in that span would lead a person to be designated a close contact and would require that they quarantine. And we have one more note here. In some cases, there are individuals who test positive but never had COVID symptoms. In that case, the period for determining a close contact isn't 48 hours before the person became symptomatic, since there were no symptoms. It's 48 hours before the sample was taken that resulted in the positive test. One of the biggest confusion factors that we've seen on this is people, I think, do not understand the difference between quarantine and isolation as public health terms. So I want to spend a few minutes and go over that. Quarantine and isolation are terms of art in the public health context. Now, we tend to use the word quarantine in the vernacular to describe anyone who's COVID positive or was exposed to COVID. But if you hear someone from the CDC or the PA Department of Health use the word quarantine, they are very specifically referring to an individual who was potentially exposed to COVID, but has not developed symptoms and has not tested positive. Those are the individuals who follow the quarantine guidance that we went through in the previous slides. If you hear someone from the CDC or the PA Department of Health use the term isolation, they're talking about someone who has been diagnosed with COVID or who has COVID symptoms. That person does actually not follow the quarantine guidance. That person has to follow CDC procedures for discontinuing home isolation. Now, those have been updated multiple times since the crisis began. So what I would recommend is that if you have someone who is dealing with this, or if you have a positive employee, you should always go to the link that we've included in the presentation here, which is the CDC website, which will talk to you about what their factors are. Right now, for a COVID positive patient to discontinue home isolation, you have to satisfy all three of the following factors. It has to be at least 10 days from the original onset of symptoms, at least 24 hours since the fever was gone without the use of medication that would reduce the fever, and your other symptoms of COVID have to have abated. So at a minimum, the time to discontinue isolation is 10 days, but it can be much longer than that depending on how severe a case of COVID the person has and how long it takes for symptoms to abate. Our final topic on this is travel quarantines for the state. This topic has changed. Late last year, this topic was changing wildly. It's been relatively stable for the last month or so. Currently, the travel quarantine period is 10 days, but an individual who travels out of state can avoid that if they get tested 72 hours prior to entering the state or after entering PA. Now, if you wait until after you enter the state, you do have to quarantine until your negative result is received. And again, we've included a link here because this topic has changed enough that it's a good idea to check the state guidance on this each time you confront this issue, just to make sure something hasn't changed. And with that, we're moving on to our next question here, which I'm going to turn over to Mary.
Thank you, John. So this question is very similar to one we handled last, I think it was April when we did this. Worth going over because the FFCRA sick leave provision has been extended through March 31st of 2021. So the question is, do I need to give my employee leave from work if they get COVID-19? And this goes back to the paid sick leave provisions of the FFCRA. Now, they are no longer mandatory. However, what employers can do is voluntarily comply with the provisions through the first quarter this year. So you can see it says 3/31/21. And I'm going to go over this real quick with a sample. Continue to claim the payroll tax rebate for employees who have not already exhausted their FFCRA entitlement. So let's assume, I'll give you 2 examples. Mary Dempsey gets COVID for the first time, get my doctor's note, I'm out for 2 weeks. Let's assume I'm making $1,000 a week. So then you have to pay me however much. That is a credit that comes directly off your payroll taxes, dollar for dollar. And that is a nice way that actually was set up by the government so that you can immediately see a result on the money you were paying out for the COVID sick leave coming out of your payroll taxes. Now, we have here, and John and I have been kind of laughing together all week, stay tuned, this may change in the next stimulus bill. Later on, John's going to talk about something that's already changed relative to OSHA guidance. So with President Biden now in office, we're also finding that a lot of these things are changing as well, day to day, week to week. But this is where we stand right now. John, if you could go to the next one, please. All right, now what are the first 3 reasons for the FFCRA paid sick leave? Well, 1, the employee is subject to a government quarantine or isolation order due to COVID-19. Okay, so that John went over the difference between quarantine and isolation. These are not high burdens anymore. I hate to say it. It seems like it's around us everywhere we speak. So if you've, been in contact with someone and the contact tracing has been done, it is okay to ask for a note. I have quite a few clients who have called me on that. Unfortunately, some are in situations where employees have tried to abuse this greatly. That's fine. Okay, we can ask for a note on that. Number 2, the employee is ordered to self-quarantine by a healthcare provider due to COVID-19. So again, that's the healthcare provider has sent us in a note. There is an acceptable self-quarantine for whatever reason, and then that person could be eligible for FFCRA paid sick leave. And then finally, the employee, there'll be more when John talks, but the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So I leave the office today, I go, John, I really just don't feel well. I'm going to run up to the Medi Center. I'm going to get tested. My test doesn't come back for 5 days. So that period of time, once I come back, can be counted. All right. So they're not that difficult to interpret. If there's any questions, usually we can kind of work through that within a 5-minute period once we hear the fact pattern and kind of do a totality of the circumstances approach. Now, these 3 types that I just talked about are paid at the greater of the regular rate or minimum wage. Okay, so we're going to go over one more example, but not to exceed $5.11 per day or $51.10 in the aggregate. So let's assume Mary Dempsey makes $3,000 a week and I'm out for 2 weeks. You're going to owe me $51.10. Okay, that's going to be my aggregate for the 2 weeks. And the $5.11 per day you can use to your advantage as well in many situations. So again, if there's any questions on that as time goes on, please feel free to call us or email us. I do believe our information is there. A lot of you I know have been dealing with this for about 10 months straight. So a couple of you are probably experts on it, but every now and then you get a tricky one and feel free to give us a call. John, did you want to add anything on those 2?
Well, I would say actually before we move on to the next slide here, one thought, the FFCRA right now is, it was no longer mandatory after December 31st of last year. It's voluntary through March 31st. And we're encouraging clients, and I think virtually all of our clients have opted to continue to apply the FFCRA on a voluntary basis for those employees who have not already exhausted their FFCRA leave entitlement. If you have someone who's already used their leave entitlement, you're not going to be able to claim the tax credit again. But I really think that voluntary expansion of this makes a lot of sense. Whether you grant the employees FFCRA leave or not, employees are going to be covered by public health orders. They're going to have to quarantine. They're going to continue to be exposed to this. It's an issue that you're going to have to continue to deal with. And I think that using FFCRA leave and voluntarily extending FFCRA leave provides a good way to keep a person tied to the workforce and off unemployment, because it can be a challenge right now to get employees back from unemployment once they go on.
I agree. I think it's very important for employee engagement and, like John said, if you have a good employee, trying to keep them a good employee, because if and when they go off on unemployment compensation, there may be a chance they don't come back, and that's not what we want to see. So I agree. I think it's a good recommendation to keep this, and this is what we've been telling our clients as well.
So the last three reasons for FFCRA paid sick leave, the employee is caring for someone who's been subject to a quarantine or isolation order. The employee is caring for his or her child due to a COVID-19 related closure of the school or child care facility, or is experiencing another substantially similar condition. I'll make this very easy. Right now, there is no other substantially similar condition that's been designated by federal authorities. They can also use these 2 weeks of paid sick leave as well, but these are compensated at a lower rate, 2/3 of the regular rate, not to exceed $200 per day or $2,000 in the aggregate. I will also say that although we're not focusing on it here because it really hasn't been an issue since the fall. To the extent, there was also an expanded FMLA provision in the FFCRA that was only available for employees who satisfied item 2 on this slide, employee caring for his or her child due to COVID-19 related closure of the child's school or child care facility. That you can also voluntarily extend through March 31st, although I suspect that in the bulk of cases where that would be applicable, employees have probably already used their allotment for that time. But nevertheless, if you have an employee who has not used their total leave allotment, that can still be made available through March 31st as well. So practical thoughts. As we observed before, whether you give a COVID positive employee leave or not, they're going to be prohibited from reporting to work under current public health orders. And the same is true for an employee who's been a close contact who is potentially exposed. If you don't extend FFCRA voluntarily, or the employee has already exhausted their FFCRA leave, unpaid leave should be granted with the option to use PTO. An employee may also be eligible for unemployment compensation in those circumstances. Another option, if you can allow remote work, and we'll be talking more about remote work in a few slides, you can allow the employee to work remotely, and maybe they don't even need to take a leave of absence. But the thing to keep in mind is that if your policies are too restrictive, you may incentivize a sick employee to conceal the illness and come to work and expose coworkers and customers. We've had a couple of clients who've had to deal with that issue. As a result of that, you have one employee who reports to work, winds up shutting down potentially an entire production line because they expose all of their coworkers. Or if you have an employee who's in a public-facing position, you may wind up closing your business to clean, posting signs indicating that customers may have been exposed. We've had some clients who've had to deal with that issue, and bouncing back from that is not an easy thing to do. So really removing an impediment for an employee who has symptoms of COVID to call off from work is very important right now. And look, does that entail a possibility of abuse? Yes, it does. But you're better off, in our experience, dealing with the potential abuse issues than you are dealing with a COVID exposure question in your workplace. So the next question we have here, are employees laid off due to COVID-19 still eligible for unemployment? The current federal emergency UC benefits, the Appropriations Act that was passed late last year extends emergency pandemic UC benefits through March 31st of 2021 for individuals who've exhausted their state eligibility. So this means that an individual should continue to receive federally funded benefits through March 31st in an amount that would be equal to what they would have received from the state. The same act also provided enhanced unemployment compensation benefits of $300 per week for any individual who received $1 in state benefits, also through, March 13th, not March 31st. I'm transposing my digits. This is essentially the same concept as the $600 that we saw in March and April, but it's a lesser amount. So right now, an employee who had exhausted their unemployment benefits due to a work loss due to COVID should be eligible for emergency benefits in an amount equal to their state benefits and an additional $300 on top of that, at least through March 13th. Unemployment rights for some self-employed individuals also remain in effect. I will tell you that we have this date of March 13th. I would expect the next stimulus is going to extend unemployment compensation benefits again and likely provide some continued enhanced unemployment compensation benefits. We'll have to wait and see. The last update I saw on the stimulus bill indicated that it would probably not be debated until late February or early March. So I think we're going to have to wait a little while for an answer on this. I will tell you that you may have gotten communications from employees who were laid off indicating that their unemployment benefits had expired, and they did expire for a short period of time. And it took the state some time to spool up for the Consolidated Appropriation Act benefits, but I believe the state started paying these out roughly 2 weeks ago. They started issuing benefit payments to employees again. So even if you've received a communication from employees that their benefits have stopped, they should have restarted. And if they haven't restarted, I would encourage that individual to contact the Unemployment Compensation Service Center. So, Mary?
Yes, thank you, John. So this is a real quick one, and we've encountered this again over the last 9 to 10 months, and it may sound somewhat simple, but it's not. The employer questionnaire for unemployment. So a lot of people call us, well, what do we say? What do we do? This wasn't, and some are mad. They're mad that the pandemic is causing them to lay off people. The pandemic is causing them to lose money. And, some don't want their employees to receive unemployment. Here's the truth. The truth's the truth, and that's what you have to put down. So here's what we've come up with. It's worked very well. It's worked very successfully. So to help employees who have lost unemployment or employment, due to COVID, here's what we've been saying, and it's worked well. The employee, and this is here for you to see, and we'll provide it if needed, has either been, you can see, laid off or had hours reduced due to coronavirus. Now you can say shut down, loss of business if necessary, but perhaps it's just a typical layoff where, last in, first out. The employer is not contesting this application for unemployment. A couple good things happen here. Number one, you're being honest to unemployment. Okay, you're putting aside personal feelings, emotions, etc. You're just putting forth an honest, subjective statement. Number two, if many of you have unemployment claims repetitively, I truly believe, having been someone who's in and out of court for 30 years, that judges and or referees respect this. When there comes a time and a place to defend a good unemployment case, don't get me wrong, but then there comes a time and a place to say, hey, here's what happened here. And I think the next time you go in, they will be respectful of that, and hopefully remember that no one created any chaos where none needed to exist in this situation. And then, again, you're doing the right thing in terms of employee engagement, because I still go back to what John said, and he's right. We're having a lot of employees having difficulty finding people who have been laid off and who are on unemployment who are not coming back. So, if we say, okay, we're admitting this, and they know that we're trying to help them during a difficult period, we're trying to give them a paycheck during a difficult period, if and when the time comes for a callback, hopefully they walk right back in the door. So that's our goal. So if there's any questions on that, give us a call.
So we're running a little bit behind here. So I'm going to move through this section pretty quickly. An employee has requested remote work. What do I do? Right now, our current Department of Health guidance hasn't changed. All businesses are supposed to conduct their operations remotely through individual telework requirements unless impossible. Now, is teleworking impossible? That determination has really been left up to the business. And for some positions, it's going to be easy. Obviously, if an employee uses equipment that's only present in their manufacturer's employer, they're going to have to come to work. If an employee is publicly facing and a business is still open to the public, obviously remote work is going to be impossible there. For other positions, it's less obvious. I mean, a lot of computerized positions can be performed remotely. Questions you have to obviously consider, are there additional job functions that require someone to be in the office? If so, maybe the answer is going to be a hybrid arrangement where a person works remotely 3 days and works in the office 2 days. Where are files and key locations key information located. Some employers are in the cloud now where employees can access computerized information from anywhere, but some employers still have to be physically present in order to access it. And then there are also real information security and HIPAA requirements if you're a healthcare provider. If you have an employee who is working remotely, you still have to make sure that your protected health information is secured and your information is protected. So if telework is allowed, you certainly want to have a written policy in place. And that policy should address all of the following elements. Information security, there's a continuing requirement to perform all key job functions. The employee has to be available to management during regular work hours. In other words, if you call them for a work-related issue, they need to answer. Timekeeping. If the employee is non-exempt, you still have to track and pay for all hours worked. So you need to make sure that the employee is tracking their time appropriately. And finally, there may be special concerns that are applicable to particular jobs that you may also want to include in your telework policy. And finally, there are also workers' compensation concerns. And I'm going to turn that over to Mary because she's much more knowledgeable in this area than I am.
Thank you, John. Yes, I have 2 decades of working in this type of law. So bad news, I hope people are sitting down. Teleworking arrangements will not remove an organization's potential exposure to a workers' comp claim. Now, am I sitting here telling you every single thing that happens at an employee's home is going to be compensable? Absolutely not. What this is going to come down to is an absolute totality of the circumstances approach, okay? So let's go over a couple examples. If an employee is injured while working at home, what will happen? So if Mary Dempsey is working at her computer and I touched in at 8 and I worked till 11:30 and then I ran to the bathroom for 5 minutes and I'm coming back because I'm finishing a strong project. My opinion, those 5 minutes that I ran to the bathroom, unless there's a strong telework policy and it says when you punch in and out, you're off work time. Because think about it, if I'm in my office today and I run to the restroom and I twist my ankle and fall on the way, that's going to be compensable. Okay. Now, alternatively, Mary Dempsey's working on her computer all morning. She has to go pick up her son at daycare. Okay. Then you get in and I'm in a car accident. Then you get into a totally different set of situations. What about someone like me who's used to being maybe in hearings or depositions or in court, and all of a sudden, because I am teleworking or I am not out as much as I used to be, doing a lot of computer work, I'm typing, I'm writing briefs, and all of a sudden my carpal tunnel starts to act up, right? Everybody's seen that. So, or ergonomical issues. I'm sitting in a chair all day and I say I have back pain because historically I would be up and about more. Or I'm an older employee with a pre-existing condition and I'm sitting in a chair all day and I have a blood clot. So again, having done this for so long, I can already see where the next 1 to 5 years is going to go here with telework. John said it best early on, have a strong telework policy, okay? That it could, I'm not gonna say it's gonna hold the day for you, but it is going to be an important evidentiary tool in any type of workers' comp case. What I also think is important is if you're, and some employees don't like this, especially if they're professionals, if your computer system allows, have them dock on it, have them go on and off. I'm in at 8, I'm leaving to go make my lunch at 11:30, I'm back on at 11:45. That record at a later date could also be a very important piece of evidence in a workers' comp case. And again, people can get hurt, hurt at home just as easily as they can in an office setting. So we really do need to be careful about that. You see, I have here causation is key. What caused it? What were they doing? Will a doctor come forth and say this was work related? So go back to my carpal tunnel situation. Go back to my back because of the chair, the ergonomic issue. Go back to my the blood clots. None of that can go forward unless a medical doctor says within a reasonable degree of medical certainty that it was caused by work. So we do have that to fall back on, and there'll always be an option to get an independent medical exam. So I will repeat, it's an individual fact-based inquiry based on a totality of the circumstances approach, but I can see it coming in the next, maybe even sooner, 1 to 5 years. I think we're going to be dealing with a lot of telework complaints. Quick, as John said, we're running a little behind schedule. ADA discussion. Mary Dempsey is working at home. Her hands are hurting her. Do you want to get her, the extra keyboard? Do you want to get her the double keyboard? Do you want to get her the double screen? Do I need a new desk chair? Okay. So all of this is going to start to come into play. What I will tell you is this: if you're going to do it for one, you're probably going to set up a precedent where you may have to do it for others. So what you want to do is you want to enter into the interactive dialogue under the ADA. We're allowed to send letters. We're allowed to get medical, a medical note that says he or she needs this. Now, if it's your star employee, they're doing everything famous or great and they're succeeding and they want a $99 chair from Office Max, I don't know that I would deny that. But if something comes to you that seems a little fishy, where someone is creating kind of a home office environment at your expense and using, certain body parts as a reason for that, again, this is an interactive dialogue analysis. One final thing on that, I am a big believer in documenting interactive dialogue because I've been in too many lawsuits where they said, well, I talked to Mary the employee, and Mary the employee says either number one, no, she didn't, or number two, they didn't understand that it was part of an interactive dialogue. So I think it's smart to document a lot of this. So with that, I'm going to turn it over to John so we can try and stay on course here.
All right. So we've labeled this section other topics, but really we should have called this section workplace safety. This is the final section of the presentation where we're going to be going over some workplace safety rules, both from PA Department of Health and some new guidance from the Occupational Safety and Health Administration. I will tell you that since we are starting the last section of the presentation, if anyone has any questions, please type those into the chat box now, and we'll handle any questions you may have as soon as we get to the end of this section. So initially, the PA Department of Health's November 27th, 2020 safety order for businesses, the COVID-19 mitigation order, remains in effect. You can still find that order online at the web link that we have in the presentation. And I'd like to emphasize that order and the guidance contained in that order is mandatory as described therein. There are some measures that are left up somewhat to a business's discretion, but for instance, masking, social distancing, the remote work instruction, those are requirements that a business is supposed to implement. And that's going to be a pretty important distinction to keep in mind as we transition into the OSHA discussion, which we're going to do now. President Biden ordered OSHA to investigate whether an emergency COVID-19 safety standard was needed, and if so, to issue that standard by March 15th of this year. Now, last week, on Friday of last week, OSHA gave us a bit of a gift. They issued some updated guidance. Now, I'd like to emphasize this as guidance. It is not mandatory in the sense that OSHA did not enact this as a rule. They enacted this guidance as a resource to employers to assist with COVID mitigation. And I've included a link to the OSHA guidance here so you can take a look at it. The key part of this is that employers should implement a COVID-19 prevention program to comply with OSHA requirements that would include, for instance, conducting a hazard assessment and assigning a workplace coordinator. The OSHA rules also address some other concerns, many of which are already mandatory under our Department of Health order. For example, OSHA has comments here to separate and send home infected or potentially infected people from the workplace, implement physical distancing in all communal work areas, and that would include investigating remote work and telework, install barriers where physical distancing can't be maintained, use face coverings, improve ventilation, applicable personal protective equipment, provide supplies necessary for hygiene and perform routine cleaning and disinfection. Now, the tricky part of this and what we don't know yet, but what I expect is going to happen, even though OSHA has not adopted a rule specific to COVID-19, or in a larger sense, OSHA has not adopted a standard for respiratory protection for any respiratory illness. OSHA does have what's called the general duty clause, which in layman's terms requires an employer to take reasonably foreseeable steps to take steps to prevent employees from suffering reasonably foreseeable illnesses or injuries in the workplace. That's a very broad standard. And I would not be surprised if even though this guidance is not a rule, if OSHA looks at this guidance to determine whether it would be appropriate to issue a citation to an employer under a general duty clause. Certainly, if you're not in compliance with Pennsylvania Department of Health orders, I think that's something OSHA could look at. So even though this is guidance, any employer should read this guidance carefully, go to the website and look it over, review the PA Department of Health order, and make sure that you've taken all of the steps that you can and all of the steps that you should be taking under those guidances that would be appropriate for your work conditions. And the reason I say that, the PA Department of Health has taken a relatively light touch with enforcement of the November 27th order. We are definitely going to see increased OSHA inspections and OSHA enforcement efforts under the Biden administration. Actually, the president has already instructed OSHA to carry out increased enforcement initiatives with regard to COVID-19. So we're going to start to see OSHA inspectors knocking. And the best way to avoid a problem with OSHA is to make sure that you're in compliance with the safety regulations before OSHA comes in. So I would encourage everybody to do that. Now, really, I've already talked about all this stuff. You do want to make sure that you train employees on COVID safety procedures, appropriately document COVID exposure and your training. And one last point here, do not retaliate against employees who raise COVID-19 related fears. We are starting to see OSHA look at some COVID retaliation issues, and there's actually a case in PA courts right now that is determining whether or not firing someone for complaining about COVID or complaining about violations of state public health orders is actually a public policy exception to at-will employment. So there's a lot of attention being paid to retaliation issues right now, and you don't want to retaliate against an employee who's raising those questions in good faith.
John, real quickly on that before we conclude, I am also handling a case right now, which is a COVID ADA case, stating that an appropriate or an adequate accommodation was not made for him or her. And as a result, it was a wrongful termination and also retaliation. So again, as we said with workers' comp, there's a whole new slew of litigation coming our way, which we hate to say, but that's the way this is going to turn. So best thing is, again, to look at that. If there's ever any questions, maybe give your lawyer a call and make sure. If you know our assistants, we're always here as well. John, did you want to conclude?
Well, I think that's really it. So, we finished up our FAQs regarding COVID. So the question is now, do you have any particular questions for us? Either something that we haven't touched on or haven't answered, or do you have any follow-up questions or need additional detail on anything we've talked about? And if you do, please put it in the chat box.
Yeah, we'll give them a few minutes to go in the chat box. I do not see one yet, but I just want to thank Victoria and the Scranton Chamber for allowing us to partner with them to do this seminar. This is always an important topic for all employers, so we appreciate it.
Thank you both. This was very informative. I think it was great to, talk about this. We do have something down below.
Oh, we do. Oh, will we receive this PowerPoint? Absolutely. How would you like to do that, Victoria? How would you like to pass that out?
We will be putting this on our website as a follow-up with this recording to this webinar, and then we will attach also the slides that John and Mary have sent to me.
Okay, great. So the answer is yes. So thank you. Okay.
Yeah, absolutely.
I don't think I see anybody else. So Victoria, if you have any other final things before we conclude?
No, I just, again, want to thank Ufberg & Associates and John and Mary for this presentation. I think it's very key to know all of these items, and moving forward, I know things are changing. So keep an eye out for any other updates we'll have. And I hope everyone has a great Thursday.
Thank you. Bye.
Thank you so much.
Bye.
Bye.